right, everyone. Good morning, and thank you for joining us today. My name is Jay Huang, and I am a senior associate at Scott Legal PC. And today we're going to spend some time talking about the visa options available for individuals with extraordinary ability in their fields. So, just a few things before we get started. Scott Legal is a full service immigration law firm, so this means we have expertise handling a wide variety of non immigrant and immigrant visa categories suited for various circumstances. So, whatever your immigration needs may be it a family based, employment based, or investment based immigration matter, we can help you find a solution. We will be continuing this webinar series, and we are doing at least two webinars a week on different immigration law topics. So definitely feel free to sign up for any upcoming ones in the future. And at the end of this particular webinar, we will be sending out a few things for the benefit of all participants. So first, we will send you a copy of the PowerPoint that will be used in this webinar. We will also send you a comprehensive visa guide that you can use as a reference that covers the visa types that we will be talking about today. We will also send you a link that you can follow to sign up for any additional webinars that are coming up in the future, and also a link to this webinar as it will be recorded. This webinar will also be made available on YouTube, and we do encourage you to subscribe and hit the notification button as we do regularly upload a variety of immigration law related videos that can be of a helpful resource to you. Finally, we will send you a link that you can follow to set up a consultation with one of our very experienced attorneys should you wish to discuss your case in further detail. Today, we're very lucky to have Katie Perez, who is a senior associate of the firm and actually used to be a USCIS adjudicator and really has a wealth of experience handling cases in the visa categories we will be speaking about today, who will be presenting about these various options available for extraordinary ability individuals and the requirements and considerations. And I will also be one of the panelists. Finally, for any questions you may have, please feel free to add them to the chat box or use the Q&A function, and we will try and get to all questions. All right, so without further delay, let us get started.
Okay, so what are the extraordinary ability visa categories? First ones we have listed here are the O-1A and the O-1B, which are both temporary non-immigrant visas. With these visas, you will have the ability to work in the U.S., but you intend to come here temporarily to fulfill that work. In contrast, a green card option would be for someone who intends to work and live in the U.S. permanently. So again, first we have the O-1A, a temporary non-immigrant visa for individuals with extraordinary ability in the sciences, education, business, or athletics. This visa category has a very high standard in which you would want to be one of a very small percentage who has risen to the top of your field in your profession. We also have the O-1B. This is another temporary non-immigrant visa for people with extraordinary ability, but particularly in the arts. O-1Bs are treated a little bit differently than the O-1A. The standard for arts is slightly lower, and the person must have received distinction, meaning a high level of achievement evidenced by a degree of skill and recognition substantially above that ordinarily encountered. There is also a subcategory in the O-1B. This is for people with extraordinary ability in the motion picture or television industry. The standard for the motion picture and television industry is a bit higher. You have to show that you have a record of extraordinary achievement in the motion picture and television industry, such that you have a high level of accomplishment evidenced by a degree of skill and recognition significantly above that ordinarily encountered, to the extent that the person is recognized as outstanding, notable, or leading in the field. So for the O-1B motion pictures and television, it's in relation to your peers within the industry. So let's see. We also have the green cards. We'll talk a little bit about those. For the extraordinary ability, we have the EB-1A. This is very similar to the requirements for the O-1A and the O-1B, but there's not a separate category for the arts. So it's all lumped in together under one umbrella for the EB-1A. So here, the individual must have been one of a small percentage who has risen to the very top of their field of endeavor, and you must have sustained national or international acclaim, and your achievements must have been recognized in your field of expertise. So importantly, the person must be coming to the United States to continue to work in that area of extraordinary ability. So if someone's had a very prominent career, and they just want to retire, come to the United States, this is the EB-1A wouldn't be something you could pursue to do that. The government would want to see that um, your proposed intent, what you plan to do in the United States, and that you want to continue to work in your field. And it must be related to your area of extraordinary ability. So we also have the EB-2, the National Interest Waiver Green Card. This one is not always lumped in directly with the extraordinary ability visas, but it's a good option for people who maybe were on the O-1B, don't quite meet the EB-1A standard yet, but do have an impressive background and they are working on an endeavor in the United States that has substantial merit and national importance. So you may be eligible for the employment-based second preference visa if you're a member of the professions holding an advanced degree or its equivalent, or a person who has exceptional ability. So for the EB-2, you do have to meet the threshold requirement of the advanced degree or exceptional ability in your field. If you're claiming exceptional ability, you will need to explain how your area of exceptional ability directly relates to your proposed endeavor. And the term endeavor is more specific than just the general occupation. You should offer details not only as to what the occupation normally involves, but what types of work you're going to undertake specifically within that occupation. So, for example, if your occupation is an engineer, then the explanation of the proposed endeavor should describe the specific projects you're going to work on, the goals you will accomplish as the engineer. You'll also need to provide a detailed description explaining the proposed endeavor, supporting documentation, evidence to establish that the endeavor is of national importance and has substantial merit. You also need to show that as an individual, you're well positioned to advance this particular endeavor. So there needs to be kind of a nexus between your expertise and experience in what you're working on. And then based on that, you would argue that it's beneficial to the United States to waive the normal labor certification process that requires the U.S. employer and a labor market test, and that you should not have to go through this because what you're working on is so important that it's beneficial to have you here in the United States. So one thing to remember, one thing that's very important about the EB-1A and the EB-2 National Interest Waiver is that you can self-petition. There's more flexibility in some ways with these petitions because you don't need to have a U.S. employer, which is not the case for many other green cards and is not the case for the O-1A or the O-1B. For those temporary visas, you do need to have a U.S. employer, a U.S. agent, or an agent operating for a foreign employer. Okay. So now we will take a look at what you need to specifically provide to prove or show that you qualify for the O-1A. So you can show that you have won a major internationally recognized award like a Nobel Peace Prize or a Pulitzer, or much more commonly, people are going to qualify on the basis of showing that they meet at least 3 out of the following criteria. So 3 is the minimum, but you would want to show more if possible. But again, you would want to base that on the type of evidence. You want to always put your best foot forward, the best evidence forward. You don't want to just throw everything at the officer because sometimes that can weaken the case. Okay, so first is the receipt of nationally or internationally recognized prizes or awards. You would want to consider, is the prize national, the whole nation? Is it international, more than one country? A prize is often something offered or striven for in competitions, contests. An award is something conferred or bestowed upon you, especially based on merit. And things to consider is the criteria for winning the prize, past honorees, the number of prizes or awards given each year, limitations on the eligible competitors. You really want to think about, was this an award you won as a student? Was it something given by your university or college? Who were the recipients? If so, if it's just given by the college, it's given to every, I don't know, a high percentage of students that go to that college. It may not be very compelling evidence to show that you've won this award. So let's see. However, if in contrast, if you were at a university and you won a very prestigious award where other professionals in the field were also competing for it, then you would want to include this type of prize because it would show the caliber of the participants and that this award really was a prestigious award. So we also have membership in associations in your field, which require outstanding achievements. Here you would want to show the membership actually requires you to have some outstanding achievement in order to be invited or in order to apply to become a member of this association. It's important to look at the requirements for entry. Can anybody enter? Does it really, and does it really require outstanding achievements? Factors you might consider, do you have to pay to join? Is it based on a level of education? Something like a bar association for a lawyer wouldn't work. So anyone who's passed the bar can join by paying a fee. So it doesn't necessarily require any outstanding achievements to be a member of the bar. So it has to have published materials in professional or major publications or major media about you or about your work or something you're working on. This should be about you, but the publication could cover a broader topic and include substantial discussion on your work and mentions you in connection to the work. You also have original scientific, scholarly, or business-related contributions of major significance. Any original contribution could be something like a patent, processes that you've developed. It's important to show how the work has already made an impact on the field. Potential impact is not sufficient for this criterion. So often people will provide testimonials about their work, about your work, but in the testimonials, we'll talk about the potential impact of your work on the field, but this is not sufficient. You really need to show how it has already made an impact on the field. We also have authorship of scholarly articles in professional journals or major media in the field. This can include publications in professionally relevant journals or published conferences, presentations at nationally or internationally recognized conferences. This criterion often comes up for people involved in academics, but it could apply to other fields as well. You also have a high salary or other remuneration for services as evidenced by contract or other reliable evidence. So again, here you're going to be looking at what is your area of extraordinary ability, what are you working on, and are you earning a high salary in relation to others in the field in your area? You can show this by comparing your salary to the labor statistics, but make sure you compare like apples to apples. If you're going to give an hourly wage, then compare it to an hourly wage, not the annual wage. Participation on a panel as a judge of work of others. So you must show that you've participated as a judge of the work of others in the same or allied field. An example of this could include reviewing abstracts or papers submitted for a presentation at a scholarly conference or serving as a peer reviewer for scholarly publications. You could document your peer review by submitting a copy of the request from the journal for your review and accompanied by evidence confirming that you completed the review. We also have employment in a critical or essential capacity for organizations with a distinguished reputation. So here you would want to explain your role within the organization and detail how it was critical or essential. Critical is you have contributed in some way that is of significant importance to the organization or establishment's activities. Essential was your role integral to the entity. A leadership role in an organization often qualifies as critical or essential. You would also need to show that the organization is distinguished. So if you're a CEO of a very small company that no one's heard of, you could likely show that you had a critical or essential role, but not necessarily that the company was distinguished. So you do need to meet both parts of that. Conversely, if you worked for Apple, this is a really well-known company. You could easily argue that it's distinguished. But if you worked in the factory boxing up iPhones, something of that nature, you would probably struggle to show that the role was critical or essential. Okay. So the O-1B visa. Again, this category is for the arts and those in the motion picture television. The O-1B has similar structure to the O-1A in the sense that you're going to qualify by either one significant national or international award, like a Grammy, or satisfying 3 out of the 6 following criteria discussed in the next 2 slides. So first is having been and will perform as a lead or starring participant in a production or event with a distinguished reputation. Evidence may demonstrate a lead role by establishing that the person has a principal role in an event or production. A starring role may be a position of great prominence relative to others in the production. So generally, with this criterion, the the struggle for people can be to show the future element. Um, it can be hard to show a future production will have a distinguished reputation in some cases because you may not have the critical reviews or advertisements like that. We also have critical reviews or other published material, professional or major media by or about the beneficiary. So here, I often saw that the difficulty could come with showing that the media is major. The government doesn't hold much weight to articles you can self-publish or that are not vetted versus an article maybe in the New York Times. So you must provide evidence that demonstrates the beneficiary is recognized for achievements that are nationally or internationally. We also have evidence that the beneficiary has performed and will perform in a lead, starring, or critical role for organizations or establishments with a distinguished reputation. So it's important to remember here that it's a critical role for the organization, not just an event or organization that an organization puts on. It was explained in the first bullet point. So a lot of times people conflate these two criterions and they are different. So, for instance, did you perform as an actor in a movie, which could be an event or a production, or did you work for the movie studio as a CEO? Was the role permanent, temporary? So, what was your role? What did you do for the organization? We have evidence of a major commercial or critically acclaimed successes in the performing arts, as shown by box office receipts, or I think I need to go to the next slide. Sorry about that. Um, as evidenced by box office receipts or record, cassette, compact disc, or video sales. This criterion does have some outdated evidence requirements on it. So, for instance, you probably won't be able to go buy a cassette anymore. So you might have to be more creative for commercial success. You may not have record sales, but maybe you're on YouTube and you have a very successful YouTube channel. Maybe you earn money from that YouTube channel and you can show the commercial success with monetarily from this YouTube channel that you've participated in. If demonstrating critically acclaimed success, the evidence should demonstrate that the beneficiary's work has received public-facing praise, positive news, reviews in the field. So, okay. We also have evidence of significant recognition for achievements from organizations, government agencies, or other recognized experts in the field. This can come in the form of a testimonial, so it should really focus on your achievements. If you speak to someone's potential or mention that they are a hard worker, just you're speaking to their character rather their achievements. This would not be sufficient for the adjudicator. So the details of the achievements are very, very important. Again, we have evidence of having commanded a high salary or other significantly high remuneration for services in relation to others. Again, you can show this by comparing your salary to labor statistics, but make sure you compare the apples to apples. So again, if you're giving an hourly wage, make sure you compare it to an hourly wage. Lastly, there's also comparable evidence. So that's to say if you're applying for the O-1B, and maybe a niche field not very common, and you feel the above criterions we just discussed don't apply to you, you would need to explain why they don't apply to you, and then explain why the evidence you're providing is comparable. This can be a big hurdle for people to overcome, and you can consider it, but I have actually, in all the years I adjudicated, never saw someone give the comparable evidence that was and show that the criterions listed did not apply to them. Okay. So just we'll recap some differences between the O-1A and the O-1B here. So again, the O-1A covers the sciences, education, business, or athletics. The O-1B covers the arts and motion picture television. The standard, again, for the O-1A is one of a small percentage who has risen to the very top of their field of endeavor. It's a very high standard. The O-1B is a lower standard. It's a high level of achievement as evidenced by a degree of skill and recognition substantially above that ordinarily encountered. The motion picture television is a level of claim substantially above that of their peers. So you can get a visa, the initial visa for 3 years. It can be extended depending on the type of work you're going to continue doing. It can be extended for a year. If you have a new job, new projects, you could also get a longer extension up to 3 years. Regarding your family, you can bring your family to the US with the O-1A and the O-1B. This includes your spouse and children under 21 who are not married. They can attend school, but unfortunately, if you have a spouse, they cannot work. They will not get the work authorization. Okay, and go to the extraordinary ability green cards. So the requirements. So this is very similar to the O-1A and the O-1B, but some of the language is a little bit different because it incorporates the arts, sciences, education, business, and athletics all together. The structure is also very similar, where you can qualify with a major award. However, most people will again qualify based on meeting 3 out of the following criterions listed in the regulations. So again, you can receive a major award, but if you don't have that, you can also show that you have evidence receipts of lesser nationally or internationally recognized prizes or awards for excellence in the field, membership and association in the field, which demand outstanding achievements for their members, evidence of published materials about you in a professional or major trade publication or other major media, evidence that you have been asked to judge the work of others, either individually or on a panel, evidence of your original scientific, scholarly, artistic, athletic, or business-related contributions of major significance in the field, evidence of your authorship of scholarly articles in professional or major trade publications or other major media, evidence that your work has been displayed at artistic exhibitions or showcases, evidence of your performance of a leading or critical role in distinguished organization, evidence that you've commanded a high salary in comparison to others in the field, and evidence of your commercial success in the performing arts. For this one, you also need to show that you would be coming to the United States to continue to work in your area of extraordinary ability and that your work will substantially benefit the United States. So the government adjudicates these petitions in 2 steps. So first you have the evidence to determine whether or not you've won a major award or that you qualify with at least 3 of the listed criterions listed in the regulations. However, simply meeting the plain language of the regulations is not sufficient. You also need to show that the totality of the evidence that you are a very small percentage of people who have risen to the top of your field of expertise. So because of the second step, it's very important to consider all the evidence you are submitting to the adjudicator. You want to look at the petition holistically. You want to make sure, again, you put your best foot forward. You're giving the best evidence you have. Throwing every piece of evidence at the adjudicator could actually weaken your case and maybe show that you haven't really risen to the top of your field. So now we'll switch to GA, who's going to go over some of the requirements for the NIW.
All right, thank you so much, Katie. All right, so now let's talk a little bit about the EB-2 NIW, which is not technically an extraordinary ability visa pathway, but there can be significant overlap with, the types of clients that we see in extraordinary ability visa petitions, and potentially this can be an option, especially if maybe someone's profile is maybe not just at the high level that is required to meet the EB-1A standard. Maybe the EB-2 NIW could be an alternative to consider. So the requirements. So let's start with the threshold requirements. Unlike the EB-1A, which has a different set of requirements, which Katie just went over, the EB-2 category has a different kind of threshold requirement where you either need to show that you have an advanced degree in your field or the equivalent of an advanced degree, or show that you have exceptional ability in the sciences, arts, or business. So, what does an advanced degree mean? It means a master's degree or a higher level degree in your field. Um, and things like Master of Science, Master of Arts, MBA, right, can apply. Um, PhD, right, or even a degree like JD or an MD, right, medical doctor or Juris Doctor, in which you have to already have a bachelor's in order to gain admission to those kind of programs. Those are considered advanced degrees. Now, if you don't have a master's degree or higher in your field, but if you have a bachelor's degree in your field, and if you have had 5 or more years of progressive full-time work experience following your bachelor's degree, then you may be able to prove that you have the equivalent of an advanced degree. So it's important to note that the 5 years of work experience must come after you've completed your bachelor's, and also that the work experience was progressive. And what does it mean for a work experience to be progressive? It means that your job duties increased in complexity and seniority over time. So if you have simply done the same things over and over again for the 5 years, then unfortunately that will not show progression in the work experience. You do need to have a very detailed employment confirmation letter from your previous employer confirming not only that you work for the full time for the required period of time, but also that your duties changed and increased in the types of responsibilities that was given to you, and maybe your title had changed from junior associate to senior associate, for example, or maybe your compensation may have changed in line with the increasing responsibilities that you took on and the more complex duties that you were given. Now, if you don't have a master's degree, if you don't have a bachelor's degree in your field, or if you don't have the required 5 years of progressive work experience, the other alternative you can consider is, can you prove that you have exceptional ability in the sciences, arts, or business in your field? And in order to show exceptional ability, you must be able to provide at least 3 out of the 7 criteria that is enumerated here. One thing to note is that exceptional ability is a lower standard than the extraordinary ability standard that we have been talking about in the context of O-1 and EB-1A petitions. So, in order to meet exceptional ability, the totality of the evidence must tend to show that you have a degree of expertise that is significantly above what is ordinarily encountered in the field. So you do need to show some sort of distinction, but you do not need to show that you have reached the very, very top of the field, that you have reached a small percentage of professionals who are indeed seen as one of the top players. So 3 out of the 7 criteria, things like if you have any degree, an official academic record, any diploma in your field, even if it is not a bachelor's, you may be able to use that towards showing exceptional ability. If you have at least 10 years of full-time work experience in your field, you may be able to use that. A license to practice in your profession. If you have commanded a high salary or remuneration as compared to others in your field, membership in a professional association. It doesn't need to be one that is only open to people of extraordinary ability. You can use any membership in a professional association in your field. And importantly, if you can show that you have earned recognition for your achievements or significant contributions in your industry or field from your peers, government entities, relevant professional associations, can you get those letters of confirmation? Or can you provide objective evidence of such achievements, such as, if you've developed new technology and publish a patent, and can you show that your patent has been cited by other people who are developing similar technology? If you have you made presentations or, publications in your area of research, and have you generated much public interest around, the things that you have done? So many different types of evidence can show, that you have earned recognition from your industry for your achievements. So a little bit of advocacy can definitely be explored here. But yes, at least three out of the seven must be submitted, and the totality of the evidence must tend to show that you are indeed someone who is operating at a level that is significantly above what is ordinarily encountered. So now that you have shown that you've met the EB2 threshold, right? The next step is also an important step is to qualify that your case qualifies for a national interest waiver. And the reason why this step is important is because the EB2 NIW is a pathway that if you are approved, you get to be exempt from what is called the labor certification requirement, which is ordinarily required if you're applying for a green card based on employment. You would ordinarily need to get a US job offer from a US company, and that US company must test the labor market first to see if there is any other US person who is minimally qualified who can take your job instead. And that's, Congress's intent to protect the US labor supply. But for individuals, for applicants who can prove the, three-prong national interest waiver factors, this requirement is exempted, right? So the special thing about the EB2 NIW is that the individual who is applying for the green card, they can submit a petition themselves. They do not need a job offer. They do not need a US company to sponsor them, but the individual can, drive forward the green card application, which can be a very significant benefit. And also because you don't need to go through the time consuming and complicated labor certification process, which can, add on, several years to the whole green card pathway. Really, it ends up being, a little bit more of a faster track towards getting the green card in hand. So that is why you do need to go the extra mile to prove why, your work in the US is so significantly important that will serve the US interest in a way that you would merit this exemption. So let's go through the three-prong matter of NSR NIW test. So the first requirement is to prove that your proposed endeavor in the United States have both substantial merit and national importance. Um, and what does substantial merit and national importance mean? In a sense, the question that you're asking is, what is the prospective impact of your work? Does your work go beyond just providing services to one employer? Does your work, the benefits of your work, go beyond just serving your immediate clients, like a bakery, for example? And if you provide, great, bread for the, neighborhood, that's great. But unfortunately, for the NIW, the government is looking for an impact that is much larger than that. Let's say you're developing a new technology that will, enable semiconductor producers to fit in more data in, a smaller chip, for example, if it's at the cutting edge of the industry, right? And if this technology is going to be patented, and if many different, companies in the US are going to be able to use and license this technology and really, improve the way that they're, manufacturing semiconductor chips, then that's definitely a much broader impact than just providing profit to your employer or providing profit to your immediate clients. So that kind of broad scale, impact and advancement to an industry is what the government is looking for when they're saying substantial merit and national importance. So uh, documents such as expert letters describing this particular problem in the industry or limitation that the industry is facing, and expert letters describing what you're planning to do and what is the impact of your particular project to that industry-wide problem. Those can go a long way to supporting that. Government pronouncement and declarations can be helpful. What is actually very helpful is if you can get a relevant government agency in the US to provide a letter of support for your particular project. So let's say you're someone who is developing agricultural technology. I don't know, maybe you're, using, yeah, a novel treatment or a novel, yeah, a novel way to, cure a blight or something like that. And what maybe your project was funded by the USDA, a very relevant agency, or you can maybe get an official from the USDA to provide a letter of support, confirming why your particular work will have broader impact to increasing, agricultural production in the United States. Things like that can really be helpful towards meeting the first prong. Other data showing importance, such as, maybe you have done similar projects in the past and they have been very successful. Or maybe if you are, you know, designing a startup idea and maybe you've already gotten traction over that. Maybe you've, been invited to join prestigious accelerators or incubators like Techstars or Y Combinator. Those kinds of, public attention on your proposed endeavor can also be very helpful in substantiating why people in the industry think that this project is going to have an industry disruptive impact. The second prong of the matter of dinosaur test is to show that you, as an individual, the applicant, or the beneficiary, if it is entity-sponsored petition, is well positioned to advance the endeavor. And for this prong, the focus is on the individual's own, track record, really, in the field that will give them the required knowledge and skills to be able to drive forward the project. So the focus will be on your education experience that is related to what you will be doing for your proposed endeavor. The government is really looking for a track record of success in similar and related endeavors. So if you are researching, technology on how to fit in more data in a particular chip, then the government will be looking for things that you've done in the past that have kind of been similar technology that is involved that is needed to make that into reality. Intellectual property can be very helpful as well if you have a record of having developed similar technology and if you've already published patents about technologies that's related to that. And if you can show that those types of patents have been cited by other people already, publications in your field, where you can show that other researchers were already benefiting from what you have done that is similar to what you will be doing in the United States, that can be very helpful. Advancements towards the endeavor, and I mentioned this in a little earlier, but especially if you're doing an entrepreneurial project, showing that you have already generated traction from the industry and the economy into your particular project can be very helpful in also proving that you're well positioned to continue advancing the endeavor. So things like incubator admission, accelerator admission, things like having secured venture capital funding, especially from well-known institutional investors. That can also serve as a validation of the idea and the fact that industry, professionals think that there is something behind this idea. If you already have contracts, especially if you have contracts with government entities, for a particular project that you're developing in conjunction with the government, those can be very helpful in showing that there is, much U.S. government and industry interest in seeing that your project come to fruition. Definitely, you need more than just a plan. You need more than just a paper plan and a proposal, right? In order to qualify for the NIW, you will need to show that you've made at least some progress in, um, uh, you know, um, making that vision into reality. You've taken at least the first steps towards that. So definitely get in touch with us. We'll be able to, talk to you in more detail about exactly what that can look like. The third and last prong of the matter of dinosaur test is that there must be a showing that on balance, it would be beneficial to the United States to waive the requirements of a job offer and thus of a labor certification. And this is really, in essence, a balancing test. So you can point to elements of prong one where you can say, well, the systemic benefits to the industry, the substantial, benefits that's coming from helping the U.S., semiconductor industry, become more competitive because of this new development of technology. Those, large scale benefits can definitely be balanced against, the ordinary benefits of saving one job spot for one U.S. worker as part of Congress's, priority to protect the labor supply. Another strategy can be to rely on some of the points that you made on prong two, well positioned to advance the proposed endeavor. Speak to your very specific and unique skills and experiences, and record of success in the field. Maybe you can prove that those types of unique know-how cannot easily be found in the general body of practitioners in your field, even if, someone tried to replace your job with, someone who has minimum credentials in the field, maybe, your particular know-how would be very, very difficult to replace. So you can point to the uniqueness and advanced nature of your contributions, which really also um, ties in well with, the types of extraordinary ability evidences that we've been discussing in the context of O-1 and EB-1s. You can really bring in those types of evidence of distinction in your field to try to prove that it will be difficult to replace you with just another professional with minimum credentials. So there are definitely a variety of strategies you can use in support of the three-prong matter of Danzer test. Keep in mind that all three prongs must be fulfilled in order to be approved for the green card under the EB2 NIW category. All right, so now let's shift gears a little bit and talk about expert opinion letters, which are a very important element in both, in all of the categories that we've been talking about, the O1s, the EB1s, and the EB2 NIW. Expert letters are a very important element. So for certain types of petitions, it is good to obtain expert letters from key individuals in the industry, including and not limited to past employers, colleagues, clients, professors, Nobel Prize winners, if you know of anyone, etc. And for different types of cases, the function of the letter would be slightly different. So let's say we're talking about O1 or EB1 petitions. The purpose of the letter would be to show what were your extraordinary achievements in the field and how does that, put you apart from the vast majority of other professionals, right? Like what is that you do that it was so special and so unique and so advanced that it really puts you at the top 1% of people in the industry, and how did that give you sustained national or international acclaim, right? So that is the kind of things that you would want to prove. And as Katie mentioned in the previous slides, it is important to focus on things that you've already done. So contributions that you've already made to the field, the impact that you've already made, that makes you extraordinary achievements that have already happened, as opposed to talking about potential. Now, when we're talking about NIW expert letters, some of the letters can talk about and should talk about the expected prospective future impact of your work. So that's what I mean when I say the purpose of the letters are a little different, depending on what category that you're applying for. Because, for example, to show national importance of your proposed endeavor, the letter needs to be future looking, right? The letter needs to talk about what is the future project that you're proposing to do in the United States, and what is the scale of impact we can expect in the future from that particular project. So definitely work with your lawyer to, really brainstorm what kind of content is appropriate for, supporting what kind of petition, because we do want to be very targeted in terms of how we frame it. Who is writing the letter? That is also very important. Usually, for extraordinary ability type petitions, we would include background information about the person who is writing the letter to help, provide the USCIS with more certainty that these people have the knowledge and insight in the field enough so that they can provide an informed and objective opinion about the caliber of your achievements. So we would submit a full-length CV, a curriculum vitae with the letter itself, describing the senior positions that the referee has held, things that they have done, and maybe they themselves may have won certain awards. So, a Nobel Prize winner, right? If you can get a letter from a Nobel Prize winner, we've obviously, described what that was about. So those kinds of background information about the referee is very important because it goes directly into the credibility of the opinion expressed in the letter. You you want to avoid getting a letter from someone who's more junior than you, generally, right? You want to get someone who's at least your peer. If you're someone who's famous, you want to have someone who's at least as famous as you to provide, the opinion, or someone who's just really, really known as one of the top experts, very famous experts. You want to, get a letter from those people to make the opinion more persuasive. How does the individual know you? So the recommendation is to have a mix of inner circle letters and independent letters. And one of the things is that those letters play different roles. So an independent letter from someone who has not directly worked with you in the past, but if they know you through the reputation that you have in the industry, those letters can be very valuable because they tend to be more objective, right? And the objective assessment of the caliber of your work can be more persuasive if it's coming from an independent expert. Now, the other type of letters that helps the case that can help the case are things like if you are trying to prove that you've played a critical role for an organization, for example, right? Then you definitely want to get a letter from someone who's at the organization itself, who has personal knowledge about the contributions that you've made and how your role was so important to the success of the organization. And those kinds of very detailed testimonies can and should come from someone who's personally involved in that organization, right? So those kinds of letters are inner circle letters where you get a letter from someone who's actually personally familiar with your work, and can provide that personal narrative. So definitely different types of letters have different functions. A mix of inner circle and independent letters tend to work the best. And the content of the expert letters should generally include a discussion, a very detailed discussion of your work, recognitions, accomplishments, and achievements. It is very important not to have the letters be general in terms of just repeating the regulatory requirements. So if you can say, oh, XYZ was extraordinary, that can be seen as a conclusory statement because it's literally just saying that this person was extraordinary. But we want to go further than that and provide USCIS with more concrete detail on what makes this work extraordinary. What was the limitation in the field? And what did you do that was different from how things were done in the field? And what was the impact of what you have done, right? And what were kind of the accolades, the specific accolades that were given to you because of this impactful work? We want to see numbers, we want to see names, we want to see concrete detail about what you've done so that the person who's reading it, even if they're not familiar with the field, they want to have a very clear picture of exactly what you have done. So definitely it is good to work with a lawyer who can provide specific advice on where to develop more content if you need it. Because, yeah, expert letters definitely can make or break a case. And it definitely plays a big role on how persuasive your case can be. All right, so let's talk a little bit about certain strategic considerations when you're trying to decide between EB-1, O-1, or NIW, what category should I apply for? The first question you want to ask is, do you want to stay in the United States temporarily or permanently? And as we mentioned in the previous slides, the O-1 category, they are non-immigrant visas, best suited for if your intent to come and work in the United States is temporary. The O-1 visa can also be quicker in terms of the processing time on when you can get the visa and come to the United States as compared to the green card options, which can be a more elongated type of process just because green cards tend to take longer to adjudicate. And the availability of visas can be more limited. So, for example, the EB-2 NIW right now, the immigrant visas for the EB-2 category are quite backlogged. I would estimate at least between 1.5 year to 2 year backlog on when, you would reach the front of the line, basically, right? Because there is a limited number of visas that are given out. every year. And for since 2022, really, the number of people who are qualified and applying in the EB2 category has exceeded the number of visas that are available, and there's been an increasing backlog of how long you need to wait, even after you've been approved for the underlying category. You just need to wait until, you reach the front of the line. And for India and China, it's always been very long, but for the rest of the world also, you would be seeing a 1.5 to 2 year backlog. Um, EB1 is current for the rest of the world. Um, the wait time tends to be shorter. However, the green card processing time itself can be quite long, and green card processing can't really be premium processed. So that is definitely something that you want to consider. And really, just as a general matter, green cards, the EB2, NIW, and the EB1A green card petitions are really meant for people who want to live in the US permanently, because once you have a green card, you also have some responsibilities. There are some limitations on how long you can stay outside the United States when you're traveling at any given time. So there can be some restrictions. So definitely this would depend on your plans, where you want to principally have your main area of residence and professional life. The other question to ask is, do you have a U.S. employer or agent, or do you want to self-petition? So the O-1 visas do require either a U.S. employer or a U.S. agent to drive forward the petition. So you would be the beneficiary, and the petitioner would be someone who applies for the visa on your behalf, the petition on your behalf. Now, one thing to note is that for entrepreneurs, it is possible to have the O-1 petition be filed by a company that you set up. And if you're starting up a new company in the United States, and if it's a U.S. entity, a separate U.S. entity from the individual, that U.S. entity can be the vehicle to drive forward the O-1 case. So if that's something that you're considering, definitely get in touch with us. We can talk about some of the special evidentiary considerations when you're going that route. For the EB1A and NIW petitions, they are both categories that do allow the applicant themselves to self-petition, to submit the petition, so there is no U.S. agent or employer required. Family considerations. As Katie mentioned in the previous slides, for the O-1 category, your spouse and children under 21 can join you as O-3 dependents. However, there is no work authorization allowed for the spouse on an O-3 visa, so that can be a disadvantage. With regards to the EB1A and NIW pathways, they are both green card pathways. And when you apply for a green card pathway, your spouse and children under 21 can also apply for green cards as dependents, and also can benefit from the work and travel authorization if they are going the I-485 route and apply for the I-765 and I-131. Okay, so let's talk about another set of strategic considerations that can be important especially when you're planning to move from a non-immigrant visa to a green card. So the first thing to consider are different qualification standards. And Katie went over this in the previous slides, but there is definitely a higher standard to qualify for an EB1A green card as opposed to an O1A and O1B. Qualifying for an O1A or O1B visa, especially for an O1B visa, does not mean you automatically qualify for an EB1A. Some more profile building may be necessary. Definitely speak to us if you'd like us to assess sort of your particular case in your profile. Timing is also important. Consider how much time is left on your current underlying visa, because some visas are harder to extend or can be subject to more scrutiny once an I-140 or green card petition is filed. And certain types of visas are more affected by this than others. Dual intent visas are not affected by this, the H-1B and the L. But other types of visas, the government may be more sensitive, such as the TN visa. Definitely also reach out to us if you want to talk more about that. Family issues, if you have children who may also need the green card, you can consider filing early to, preempt there being any issues with the child aging out at 21, at which point the child may lose the ability to qualify for a dependent card. All right, so the final question to answer here is the simple question that are extraordinary ability categories available for entrepreneurs? And the answer is a resounding yes. EB-1A and EB-2 NIW both allow for self-petitions, making them both possible and attractive options for entrepreneurs who may not as easily be able to, secure a U.S. job offer from an unrelated company. Changes in the NIW standard under matter of NANISR did make NIW a much friendlier category for entrepreneurs. So it definitely does remain that it is a viable category for entrepreneurs. Recent changes to the policy manual and other adjudicatory trends do make it a bit challenging to qualify with a more smaller scale endeavor. But definitely talk to us. And we'll happy to be, discussing with you some of the approaches you can use to prove a broad impact of your endeavor. It is possible also to apply for an O-1 visa as an entrepreneur if you have a separate corporate entity that can act as a petitioner, and we mean a U.S. corporate entity that is considered a separate legal entity than the individual who is applying for the visa. All right, so any questions? Katie, do you want to take the first one? Do legal field professionals qualify for an O&A? You're a mute. You?
Sorry about that.
Yeah,
I couldn't
no
get to the
worries.
button. Yes, so potentially they could qualify. Again, you want to make sure you're falling in the right category. So the O&A would be for someone within the sciences, education, business, or athletics. So a legal professional could maybe potentially qualify in an educational field or business. Um, it's not so much limited to like a job type. I mean, you have to fit in one of the fields, and then again, you have to be able to satisfy at least three of the criterions listed in the regulation or like a major award or something like that.
All right, so I'll take the next one. Can state government employees successfully apply for NIW due to public interest service without any publications? So, just by working at a government institute is likely not going to be enough. It will really depend on what your role is within the government agency and how and if it's a project that you're working on and if it's a very impactful government run project, the important question is what is your role and how critical or how indispensable is your role? Like, so there are many different levels of government employees, and not everybody under the sun is going to apply, be a successful NIW applicant. And just because, there are things maybe like lower level administrative tasks that really can't be done by anyone, right? And if if your involvement is kind of more marginal like that, then it could be, a much harder case. But by contrast, if you're at, a more indispensable level, kind of directing a particular project that's, that is very important to the government, you may be able to build a case through, getting letters of support from senior government officials on why they need particularly you to lead that. So it really is a fact by case, fact by fact inquiry that we would do. Definitely schedule a consultation. Uh, just by being, employed in a government agency will likely not be enough. But if there is more to the case, then definitely something we could explore. And this question, I think, very specific facts. So, in terms of specific fact patterns, the consultation, having a consultation with one of us would be the best way to really look at the applicable facts and see which options may be applicable, may be viable for you. With regards to, do you do attorney mentoring for EB1A? Um, I don't know if we do mentoring, but if you want to hire us to on an hourly basis and kind of work together on a case, we may be able to explore that. Definitely schedule a consultation with us. We can, discuss further on what can be arranged. It will likely depend on, the what is being done. Yeah, with regards to very specific uh, procedural questions, definitely reach out to us for a consultation so that we can look at this with more time and more detail. With regards to the number of recommendation letters, it really depends on what you're trying to prove in the petition and depends on the case by case. Generally, we tend to see somewhere between 4 to 8 letters, anywhere between 4 to 8 letters. That's the common number that we see with regards to expert letters.
I would say focus on the quality over the quantity. A
Yeah,
lot of times, if you have the same letter just printed over and over and you have the person just signing down at the bottom, it doesn't hold as much weight. It doesn't really seem like it came from that expert.
very
So
good
it
point.
is over quality over the quantity for sure. You could have
Yeah.
one letter from the president. You might not hold much weight with that
True.
anymore.
That's funny.
Maybe a different president, but
Yeah, that's
one
funny.
letter could really do the job. But if you, again,
True.
I've seen people submit tons of letters, 10 letters, and they say the same exact thing, verbiage exactly, and it does not hold as
Yeah,
much weight. So it's really
yeah,
quality over the quantity.
yeah, definitely a good point. Uh, Again, yeah, definitely for specific case inquiries, the consultation is the best venue to do that. So please use the link that we will be sending to schedule a consultation with us, and we'll be happy to look at all of the detailed questions that you have. The last question, can someone who overstayed their visa apply for NIW EB-2? So there are two steps to applying for a green card, and the first step is to apply for the I-140 for the underlying classification. You can apply for the I-140 with regardless of any issues with maintenance of status, but the important thing is when you're trying to when you're trying to be eligible for the green card itself, that will obviously be an issue. So the I-485 part, or the immigrant visa, you do need to prove that you're not subject to any inadmissibility, and that you have maintained legal status. So at that point, that is definitely going to raise issues. So definitely get in touch with us. We'll help you figure out what options you may have in your specific circumstances. Yeah. Okay. So it looks like we've gone through all of the questions. Thank you so much, Katie, for your time and for your insight.
Thank
And
you.
thank you, everyone, for your participation. And I hope everyone has a great day.
Bye. Thank you.
Bye.